Domestic violence comes into play in divorce in two different areas. Number one, it has an effect on an alimony determination. And more importantly, number two, it has an effect on the parenting plan and time-sharing issues. In terms of the alimony, if there's been a history of domestic violence, sometimes that plays into the theory of the spouse who is trying to be awarded alimony, that they're so beaten down, so traumatized, that they've been diagnosed with post-traumatic stress disorder and they're unable to work. They can't produce any income, they can't have any self-support, and so they're looking for the maximum amount of alimony. And not only the maximum amount of alimony, but even in a short or moderate term marriage, they may be asking for permanent alimony, because extraordinary circumstances allow the court to award permanent alimony in a short or moderate term marriage. In terms of the parenting plan and time-sharing schedule, if there are convictions for domestic violence, then the court is favorable to awarding sole parental responsibility for the children, which means that the victim spouse can be making all decisions for the children without the input of the perpetrator spouse. Sole parental responsibility is a very powerful thing that will isolate the parent who does not have sole parental responsibility from a whole lot of influence in the children's lives. Also, if there's domestic violence, one of the custody factors in the statute talks about whether or not there is domestic violence, and the court can consider whether there's been domestic violence in fashioning the appropriate time-sharing schedule. That can be one of the reasons why a 50-50 time-sharing schedule is not appropriate. And if you're interested in getting a time-sharing schedule that's something other than 50-50, then that's one of the reasons that you can go in and ask the court for something more than 50-50 time-sharing.